All rise. The Court of Appeals Division 1 is now in session.
Good morning. Please be seated.
Morning.
This is our case 1CACV 21-0216, Schooley versus Pena. Each side will have 20 minutes to present their argument. You may reserve time for rebuttal if you choose, but you'll have to manage your own time. We are recording the argument, so when it is your turn to speak, please identify yourself and your client so that when we listen or review the argument, again, we can keep it very straight. The video will be on YouTube in a couple of days, so you can see how well you did. We've read the briefs, we've conferenced the case, we understand the law and the facts, so when you begin your argument, just start right out with what you would like for us to talk with you about. Counsel, you may begin.
May it please the court, my name is David Abney. I represent the plaintiff's appellants. With me today is my co-counsel, Sophia Algeri. And you did get the name right, it is Schooley. So I thought it was Schooley for a long time. I was up till 1:30 a.m. this morning working on a reply brief in a different case, and I discovered two things. One is I finally understand Gibson versus Casey. Since it's a 2007 case, I think that's quite an accomplishment. And I shouldn't stay up so late. But in any event, the issues in this case are straightforward and I hope moderately clear. There was service of the relevant documents, writ of garnishment documents, default documents on farmers through the only way you're supposed to serve, which is by statute 2221 subpart B, service shall be made only by service of process on the director. And service of process was made on the director of the Department of Insurance. In addition to that, we know from what Farmers has told us that the department did send on the documents to Farmers. It was received by 3 different functionaries at Farmers. And basically each one of them sort of mentally scratched their heads, didn't know what to do with it, but didn't go any further with that, didn't call up the legal department and say, we've got these odd documents we don't understand. It's a writ of garnishment, there's a default.
But counsel, your client's counsel had been dealing with Farmers Counsel, correct?
Yes, and Farmers Counsel had rather emphatically said, we don't represent this guy. There's no coverage. Deal us out of this particular deck. There was some further discussion about that. Well, who would be representing farmers in the event of bad faith action? And the farmers' lawyer said, not me.
But if you, in the absence of knowing who is representing farmers in your particular action, if you knew that the counsel whom you have been talking with represented farmers generally, just to make sure that there is no inadvertent default, wouldn't you let them know, hey, here's what we're doing?
Well, she didn't say that I represent farmers generally, that I'm the go-to person for anything to do with farmers. She never made that representation. She was dealing with a very discrete issue as do they represent Pena.
But counsel, under 55A, what's the definition or what's a reasonable reading of a related matter? I mean, you don't have to be counsel in that matter, but in a related matter, certainly.
But she didn't. She specifically said, don't represent.
She denied coverage.
Yeah, well, she said, I don't.
That's not related to the garnishment?
No, because it talks about knows that the party claimed to default is represented by an attorney in which the action is, in which the default is sought, or in a related matter. But she had specifically said, don't represent him.
She doesn't represent Pena.
Right.
But she did represent farmers.
Well, sure, she was Farmer's lawyer.
But how's that not
representing Pena.
Yeah.
That was the only reason she was around, because of Pena.
So how wouldn't that be a matter related to the garnishment?
Well, sure, Your Honor, it is related, but you have to back up into the rule and take a look at what it says before that. It says, is represented by an attorney. And she specifically said, don't represent him, and of course, she did don't represent him in what? In that related matter.
But
So sure, there can be a related matter.
But Mr. Abney, this is a garnishment,
Right.
and a garnishment is a separate civil proceeding,
Yes.
okay? And the garnishee, right, is occupies plaintiff, right, and garnishor, right? So in that proceeding, farmers occupies the place of a defendant, correct?
Correct.
Okay. So you have, I believe what my colleague, Judge Brown, is saying is you have a related matter where farmers is known to be represented, and this garnishment is related to that matter, and farmers is the defendant. So talking about how that person didn't represent Pena, it gives me some pause. So can you talk about how you resolve that conflict?
Well, I resolve the conflict by looking at the precise language of the rule, and the precise language is represented by an attorney in the action, and nobody knew that she was representing farmers in this particular garnishment proceeding. She had never said that or anything implying that. And as far as the related matter, sure, there's a related matter. I'm not going to try to shoeshine the court here and say there's no related matter. Certainly there was a related matter, but she emphatically said, don't represent him. We don't represent him. This is not, there's no coverage. Go by, have a
But
nice
she
day.
wrote the letters on behalf of farmers.
Sure.
Sure. I mean,
For that particular issue relating to Pena, but not relating to anything else. She was very precise about one thing.
and those
represent.
letters related to what? Denial of coverage.
Well, yeah. Yeah, sure.
But doesn't that...
For Pena.
Isn't the court maybe the court, maybe I misunderstood, but I thought the court was going to, is litigating, unless we set this aside, the court is going to litigate in the garnishment action whether there was in fact coverage, whether coverage should have been applied. Isn't that farmer's defense, that there was no coverage?
Right. But that is, the related matter we're talking about here is Pena. She never made an appearance for farmers for any other reason.
Understood, but yeah, you're saying there has to be formal representation in the related matter?
Or at least some indication that she was representing farmers. We know she was representing farmers in the related matter, in the sense of Pena, coverage, no
I
coverage.
guess it goes to the point, what does represent the party mean? That
Well-
doesn't mean notice of appearance, it can't mean that.
Well, no, I don't think it does. But there was no indication. She was representing farmers for purposes of the garnishment and that sort of
Well,
thing.
understood that, that's understood, because how could she?
And in fact, she was...
How could she when she didn't know that it had been filed?
Well, farmers knew. The Superior Court
I'm
judge...
talking about she, the attorney.
Well,
Yeah.
but you also have to take a step back and look, what did farmers know? Farmers knew, according to the trial court, that there had been service, good service on farmers. The trial court, the commissioner twice said that. There had been good service on farmers. So we know farmers got served, which is what we're supposed to do. And in fact, according to that statute, you only serve the director of the Department of Insurance. You don't serve anybody else. That would be a violation of the statute to serve
Unless
somebody
Rule
else.
55 applies.
Well, the statute would overrule Rule 55. But even if the statute doesn't overrule
How
55...
so? How, do statutes overrule rules?
Occasionally they do, Your Honor. This is one of those occasions.
All the time. What's the general rule? They read them together. To the extent appropriate, we try to read them together.
Yes, but then again, if there is a conflict between a statute and a rule, the statute controls. There's going to be some exceptions where the Supreme Court says we are the power here and we control. But in this case, the statute's very specific about who you serve. You only serve the director of the Department of Insurance. You don't serve anybody else.
Well, with regard to the party, I would agree with you. But how is a known counsel in a related matter, how is serving that person inconsistent with serving the party and counsel? Because Rule 55 talks about serving both.
Yes, but then again, I'm not trying to tell the court there's no related matter here. Certainly there's a related matter, but if you read the rule, it specifically says that if the party requesting entry default knows that the party claimed to be in default is represented by an attorney in the action in which the default is sought, that doesn't really apply, or in a related matter. But the farmer's lawyer was very clear, very strong. We don't represent this guy. We don't. Sorry. Have a nice day.
But he still represents farmers in this whole matter.
Yeah, she represented farmers in one sense, in relationship to Pena. That's what she was representing farmers about for that one sense. And you get this, of course, you always get this odd situation with insurance defense lawyers who've got two hats. Sometimes they wear both, sometimes they put one in the closet. In this particular case, it doesn't really matter. We know what the related matter is, but she specifically said, don't represent him. Farmer says, we have no coverage for this guy. We don't represent him.
Well, but counsel, we look with disfavor, I think, on default judgments. We would rather have matters resolved on the merits. Your reading of this rule goes against that policy. I don't understand what policy your rule would support.
If it supports finality, when there has been true notice, and there was true notice, the trial court, the commissioner acknowledged twice that there was good service on farmers through the Department of Insurance. And we know as a matter of fact that service went into the farmer system, went to 3 different officials in the farmer system, and all 3 of them said, we don't know what to do with it, and did nothing. But there was service.
Counsel, the record reflects that the application is not, that was served ultimately on farmers, and I agree it got to them, but it did not reference Pena or the denial of claim. So what was there about it to distinguish it from any of maybe the hundreds of garnishments they get for their employees for spousal maintenance and child support, for instance?
Well, that he wasn't an employee, and it did indicate that this was a different kind of a situation. No employment language was in there anywhere, no wages, all that sort of stuff wasn't there. What we had here was a very discreet and interesting 2 packets of documents, actually, that farmers got. And the 3 farmers people didn't do anything with them. And farmers had notice. It had de facto notice, actual notice, through its 3 functionaries. And then it had the official, statutory, mandatory, serve the director only kind of notice when they complied with that by serving the director. And I agree, to return to an earlier question, I agree. Public policy, you want to resolve things on the merits and not on technicalities, I know that. But the technicalities exist there for a reason, so that there will be finality when you have gone through the steps that the Supreme Court and the statutes have set up for getting a default judgment. When you do all those steps, you're entitled to the default judgment, you're entitled to the garnishment writ, and away you go. I mean, sometimes you get into a situation where there's nothing you can say other than, we don't know what happened. And clearly it was carelessness, treble carelessness here on the part of 3 of these functionaries. And when you get to one of the situations where the only explanation is, we don't know, and it's carelessness, then you get the benefit of the statutes and the rules concerning a default judgment. I would agree with you. I would have done things slightly differently, but you don't have to. And my co-counsel didn't have to. She had the situation where she followed the rules, the statute to the letter, and the result got this default judgment, and it should hold. Once in a while, you apply the rules as they are written, and there's no way to wiggle out of them. I know I've tried in countless appeals to wiggle out of rules, and sometimes I win and sometimes I lose, but in this particular case, I'm not trying to wiggle out of any rules. I'm trying to wiggle into them and try to uphold the system that the Supreme Court and the legislature set up. If I may reserve my time, now that the stunned silence has descended.
Yes, thank you.
Thank you, Reverend.
May it please the court, good morning, Lawrence Caston for the appellee, Farmers Insurance Exchange. Think of all the things that I was prepared to talk about this morning, responding to an argument that Coverage Counsel didn't represent farmers on what is effectively a coverage dispute, is sort of not one of them. I think the matters plainly are related. With respect to whether or not Farmers Coverage Counsel represented farmers on this matter, the McLean case is actually quite interesting. In that case, there was a contract, and the contract merely mentioned two lawyers to which notice had to be given. And this court held that is enough to trigger the responsibility under Rule 55A to give those lawyers notice. If you have to give those lawyers notice, then surely the lawyer that you've been discussing coverage about for over the course of several communications also is somebody that you have to give notice to under Rule 55A.
Counsel, the McLean case seems pertinent, but it's my understanding that case is under review upstairs. Let's assume the Supreme Court reverses on that. How would that affect your proposed analysis?
I think it would depend on why the court reversed it. But if we go to the fundamental question of whether Rule 55A governs in this case, plainly it does. The court asked an interesting question, and that was, how do we resolve this interplay between a statute and a rule? As it turns out, in Arizona, we have an interesting statute, one that I didn't know about until this case. It says, our legislature has declared that all statutes in this state that pertain to pleading, practice, or procedure must be deemed to be merely rules of court, and they're always subject to supplementation or even modification by the Supreme Court when it enacts the rules of civil procedure. That's ARS 12-111, and that's precisely the rule that's precisely the statute that was interpreted in the Gonzalez versus Whitney case, which held, in fact, that the rules of civil procedure apply in garnishment cases. If Gonzalez were overruled by the Supreme Court, then we'd have to understand why to decide how that affects this case. But my read of where they're granting review on McLean is not to overrule Gonzalez, but we'll see. Obviously, it's hazardous to predict. If I could move on to the Rule 60 question, I think this is one of.
Can you go back before you go to Rule 60? So, if this Rule 55 issue is so clear, then why did the trial judge not address it?
He expressed some skepticism, and Your Honor. My podium seems to be falling apart.
Right there.
And he expressed some skepticism, and but ultimately said that the principles of Rule 55A, that is, this idea that in Arizona you give notice to known opposing counsel, that the principles supported his ruling, and he made an express finding that on this record, based on the representations that had been made to him when he entered default, and based on what he understood to be the facts once he had a complete record, that it would have been reasonable for counsel to have alerted Farmers Counsel to the default, and he said that that supported his Rule 60B analysis. So even if Rule 55A does not apply in this case, at a minimum, it supports the trial court's exercise of judgment, discretion, because we know that in Arizona, a factor in deciding whether default should be lifted under Rule 60B, one factor that can be considered is whether or not opposing counsel was notified. That's the Addison case. It was cited on page 41 of our brief, where it said that that factor reinforced this court's decision to affirm an order vacating entry of default judgment. I think on the Rule 60 question, and that this is one of those appeals with which I think this court is obviously familiar, that really begins and ends with standard of review. Commissioner Garbarino, the judge who entered this default, who granted relief from the default, was the same judge who had entered it. He was in the best position to know why he'd entered default in the first place, to know which representations had been made to him that were important to him, and then to decide whether the default was still appropriate once he had a complete record. Our Supreme Court is actually...
Isn't he looking at basically the same documents we are? What else could he have been looking at that would have made it different? I mean, to as Mr. Abney put it, that shows the carelessness of farmers in handling the document. What else?
So he was the one to whom representations were
Was there
made.
testimony presented to him on the point of whether Rule 60 applied?
Declarations, undisputed declarations.
Which we read those the same as him.
Sure, but I think the important thing is that he was the one that had the discretion in the first place whether or not to enter the default, and he knew why he had done so. And he knew what representations that had been made to him mattered to him. He didn't express those on the record. But
True, but he also gave us a little red flag. He called the evidence thin.
He said it was thin.
Doesn't make us feel real good about it. I mean, again, you've got some carelessness here, to say the least. And so, why should farmers be rewarded for that?
So I don't think it should be rewarded. I think what it should happen is it should have its day in court. And so when this court has, and the Supreme Court have talked about the very broad discretion that we give trial courts in this context, and our Supreme Court has equated that discretion with the discretion that we give to juries. It's that deferential. And so I think, so why? Why do we give them that kind of discretion, especially here when they grant relief from a default? And the answer is, and it goes to this question of whether farmers is going to be rewarded, is that if this court affirms, all that means is that the coverage issue will be resolved on the merits. Plaintiff has made impassioned arguments about why there's coverage here. And if this court affirms, all it means is that he gets to try to prove them. But on the other hand, if this court reverses, finds an abuse of discretion, then farmers never gets its day in court. It loses a case that is very significant economically without resolution on the merits. And I think that's why this court, this disparity in potential results is why this court has made clear that it should be even more reluctant to reverse an order vacating default than to reverse an order denying a motion to vacate. What did Judge Garbarino do here? Well, he knew why he'd entered default in the first place, and then when he had a more complete record, he was able to go back and ask the question, which respectfully this court is not able to ask, which is, would I have done anything different if I'd known? I would submit, Judge Brown, the fact that Judge Garbarino said that he thought it was a little thin is a reason to affirm, not a reason to be skeptical, because he's signaling that it's a close case. And the Supreme Court and this court have said what to do in a close case. Any doubt has to be resolved in favor of resolution on the merits. What's the case that says that? Any doubt? The Roll case, I believe, and then there are a couple of cases that equate. And Roll wasn't even a garnishment case, I don't believe. And there are other cases sort of suggesting that the deference is even greater in garnishment cases.
And so, Mr. Avenue talks about the interest of finality. What finality interest does exist in this case?
I don't think there is much of a finality interest here. I mean, that is the competing interest in any default cases. There's a time when you ought to say, sort of, enough is enough. The coverage dispute, if it had been resolved in the usual way, that is in a normal lawsuit, not a garnishment where coverage had to be decided, we'd be pretty much on the same track where we are here, other than the delay for the detour up to this court. To respond, I think this answers the question in a general way too, and also responds to one of Judge Brown's questions about whether farmers could have done better here. Surely. I'm not here to stand here to say that farmers couldn't have done a better job. They were confused about what they were looking at. That's clearly the case. And in candor, I've looked at the writ a number of times, obviously in preparation for this appeal. I feel pretty confident that I would have been confused too. The writ, it only identifies the debtor. Mr. Pena. It doesn't identify the insured or give any reference to the claim. It really didn't give farmers much of a chance to identify what property of the debtor it might have. And I'd ask the court to contrast what the plaintiff's counsel did in this case with the writ of garnishment and with the default papers, with what plaintiff's counsel did after plaintiffs obtained the default judgment. So the default judgment is entered on December 4th, 2020. That day, plaintiff's counsel writes a long letter to the claims department, attaches the default judgment, identifies the claim by number, identifies the name of the insured, and says, I've got this default judgment, pay me. Claims got it to legal within a day, and she heard back immediately. None of that was done with respect to the writ of garnishment or the default papers. And this argument that's being made, this argument is sort of, well, you know, we dropped just enough breadcrumbs here to be able to say that farmers should have connected the dots. I think that's really the argument. Oh, well, we didn't have to give notice. We served. We didn't have to say anything in the writ of garnishment, even though they clearly knew how to do so once they obtained their default. I think that argument really is inconsistent with the policy of the state, exactly for the reasons you've mentioned, Judge Howe. It is the policy of the state to resolve cases on the merits. Whether or not Rule 55A applies in this case, it is the policy under the civil rules that you pick up the telephone and you tell your opposing counsel, here's a default judgment. Why? Well, I presume it's because the Supreme Court, when it enacted this rule, this court, trial courts, are sick of cases like this. I imagine a bright line rule is a pretty nice thing. If you tell your known opposing counsel, the defendant is going to have a really hard time to stand before the court and say, well, there's still excusable neglect here. I suppose there might be a circumstance, but on the other hand, when you don't do it, your default judgment is at risk.
Mr. Abney makes the argument that Farmers Council made it clear that we don't represent Pena in this matter. Does that matter in the analysis? You still have to serve when the attorney saying we're not involved in this at all.
Yeah, I don't think it does, Your Honor. I think that was a statement that we are not going to defend Mr. Pena, the tortfeasor, the criminal, because there's no coverage here. She never disclaimed that she was representing Farmers Council, and counsel never disclaimed that she was representing farmers, the garnishee here, and plaintiff knows that. I mean, plaintiff continued to communicate and said, I'm thinking of suing you, I'm thinking of, all these things, and so knew who she was dealing with when it came to coverage questions. And so this notion that the garnishment is somehow not the same as the coverage issue, it is the same thing. I mean, that's ultimately what they would have to prove on the merits.
Thank you.
Unless there are further questions, I'm prepared to wait the rest of my time.
Thank you, counsel.
Thank you, Your Honor.
Mr. Abney.
It is the policy of the state to try to resolve cases on their merits and non-technicalities. It's also the policy of the state to allow for default judgments and default proceedings. So we've got two policies. In this case, the scale should tip in favor of the policy that says if you follow the default rules, if you follow the default statute, then you get your default judgment. And if the other side was confused or did nothing or can only come to court and say, we don't know what happened, this is an X-Files matter, we don't have any clue what happened here, those are not excuses that the courts have allowed.
If Farmers Council had been notified, would we be here today?
The attorney.
I think I have a little fog in my brain. Could you repeat that, please?
If Farmers Council had received a phone call or with some notice, would we be here today?
Oh, I'm sure we'd be here, but we'd be here and I'd be in a much stronger position. But yeah, sure, I mean, farmers like to fight, we'd be here, but still, I think we have a much stronger argument on our side. But we didn't have that. What we had was what we've described, which is compliance with the statute on who you're supposed to serve, and then the information gets to farmers, and farmers does nothing with it. I talked earlier about the statute that I think controls in this situation. It's ARS Section 12-1583, and it specifically talks about when you filed an answer and you've got these materials that need to be served in relation to a default. It says, you file and serve a copy of the answer on the judgment creditor for whom the writ has been issued, which was done, or on his attorney if the party is represented by counsel at least 5 days before the appearance date. But the attorney did not say that she was representing farmers in relation to this particular kind of matter. The only thing that she had done was to put on the two hats and say, represent farmers for Pena, and I represent Pena, and there is no coverage. This is outside the policy. Basically stop bothering us, we're done.
Mr. Abney, if there's a dispute about coverage, what belonging to Mr. Pena did farmers own?
The insurance policy. That was the property, the insurance policy to provide coverage, if we're correct.
But you can see kind of where I'm going with this. If there's a dispute, and I don't think anyone questions that there was a dispute about whether or not there was coverage under this policy. But if that matter is definitively in the gray, why does a garnishment proceeding even pertain versus a bad faith claim, right?
In a sense, it could evolve into a bad faith claim, because you need an assignment and whatnot. But as far as
isn't the usual process to go get a Dameron-Morris agreement and then to go sue the insurer for bad faith?
It can be, sure. You could follow that route. But here we had a default, and we had
against Mr. Pena, though, not against farmers.
Yeah, but the thing that farmers had was the policy. You say a little bit gray as far as coverage or not, and that's fine, but it's still a legal obligation. It's a chose in action, as they say in France, and it really matters because that is a kind of property, and you can garnish it, and I believe it was pretty clear that Pena was, at least on paper, appeared to be an insured. His father had the policy, and he was operating the vehicle with permission, so he's an insured. So there is a right here that is at issue. There is a property right that is at issue, and you can garnish that property right. And if farmers doesn't come forward in a timely manner and say, no, we've got defenses to this, that, and the other, there shouldn't be anything going on against us, and here's why, that's fine.
Was there
an opportunity to do that?
I'm sorry to cut you off. Was there a threat to sue farmers for bad faith?
Sure.
That was communicated to the attorney in question?
Right. And she said, no, I'm not going to represent them for bad faith.
But does it not form some basis for potential confusion if you have someone saying we're going to sue for bad faith and then they don't sue for bad faith, they pursue a garnishment? Does that not form a point of ambiguity there?
That's why these insurance companies have such sophisticated legal departments, because they do get knotty legal problems and they solve them. They come up with an answer and then go forward. So this was something the insurance legal department could have resolved as far as what to do, could have appeared, could have fought this, and none of that happened because farmers, although it was served properly through the Department of Insurance and actually got service, 3 officials got service, farmers did nothing.
And just to move, because I know time is short, do not courts have an independent obligation to protect due process of litigants?
Sure.
And doesn't that have to work in conjunction with any kind of statutory framework that comes with us?
Yes.
We have an independent obligation to make sure that due process is observed?
Yes, Your Honor.
Okay,
Now, as you're walking down that path, it was a Robert Frost, I was in the woods, and the path went 2 ways. You can certainly go the path farmers' way, or you can go the path of also recognizing that there's due process on the other side. We've got statutes and regulations that govern what happens when there is a default kind of situation. And you're entitled to choose which path to follow, but I submit to you that the proper path here...
I agree, and with your last minute, can you please explain to me the prejudice if there's an affirm here? Because counsel's argument was there isn't one. You go and you have your fight.
Oh, the prejudice is we've got a default judgment. We've got essentially money in the bank because we followed all the procedures. We followed the rules, we followed the statute, and here it is, we got it. It's our chosen action, and we have a right to enforce that chosen action. Now, farmers are trying to snatch that away. So there is prejudice, there is a problem here if the court chooses the path that we believe is the wrong path and winds up in the snow. Wonderful poem, by the way, one of my favorites. Anyway, thank you as always so much for your time. It's always a pleasure and an honor to be here. Thank you.
Thank you, counsel, for your argument today. We'll take this matter under advisement and we'll issue a decision in due course. We stand adjourned.
Will I be receiving a bill for the podium?